welcome to Verdictum. I am Ananya Singh and you're watching today's legal news, where we apprise you with the recent important legal developments across the nation. Here are the headlines. Accused in Lakhimpur Kheri violence, Ashish Mishra allowed to stay in Delhi for treatment of mother and daughter by the Apex Court. Whether arbitration clause in insufficiently stamped agreement valid, Supreme Court refers case to 7-judge bench. Gujarat High Court grants time to state for filing SIT's final report in Morbi Bridge Collapse case. NCLAT to begin hearing from November 28th of Google's plea challenging imposition of Rs 936 crores penalty by CCI. NGOs registered under FCRA will need to provide details of foreign funds after MHA amends rules. Now let's take a detailed look on the headlines. A 2-judge bench of the Supreme Court comprising Justice Suryakant and Justice Dipankar Datta today granted permission to Ashish Mishra to visit and stay in Delhi. Mishra is the prime accused in the Lakhimpur Kheri violence that took place in October 2021 in Uttar Pradesh. Allegedly, Mishra's vehicle rammed over 5 people who were protesting against the then introduced farm bills, killing all 5. A counter case was also filed following the incident, claiming the protesters lynched 3 persons to death, including the driver of Ashish Mishra. Ashish Mishra is the son of Union Minister Ajay Mishra and was arrested following the Supreme Court taking suo motu cognizance of the matter on a letter alleging police inaction. The Apex Court also constituted a SIT composed of retired High Court judges to monitor the probe. Mishra was granted bail by the Allahabad High Court in February 2022. But the same was cancelled by the Apex Court in April the same year. In January 2023, the Apex Court granted Mishra interim bail for 6 months and imposed the condition that he will not be entering Delhi and Uttar Pradesh. The present order comes as a modification to the January 25th order, after Mishra filed an application before the Apex Court seeking modification of bail conditions, stating his mother is admitted at a hospital in Delhi and that his daughter needed treatment for a deformity. The bench relaxed the condition, however, restricted Mishra from participating in any public event in Delhi and barred him from interacting with media in relation to the case that is pending before the top court. The bench also clarified that Mishra will remain to be prohibited from entering Uttar Pradesh except for attending the trial. The Supreme Court's 5-judge constitution bench today referred to a 7-judge bench the issue as to whether the arbitration clause in an unstamped or insufficiently stamped agreement will be valid. The present bench, headed by the Chief Justice of India D.Y. Chandrachud, and also comprising Justice S.K. Kaul, Justice Sanjeev Khanna, Justice B.R. Gavai and Justice Suryakant, observed that the issue has caused limitless uncertainty in the area of arbitration law and had to be considered by a larger bench. The bench held that having regard to the larger ramifications and the view of the majority in the case titled NN Global Mercantile Private Limited versus Indo-Unique Flame Limited and others, we are of the considered view that the proceedings should be placed before a 7-judge bench. Notably, in April this year, in the case of NN Global, as mentioned previously, a 5-judge constitution bench of the Apex Court had, with a 3-2 majority, ruled that an agreement which is not sufficiently stamped cannot be said to be an enforceable contract as per Section 2H of the Contract Act. The present plea is a curative petition challenging a judgment dated February 14, 2020 that held that an arbitration clause in an agreement required to be duly stamped and not sufficiently stamped cannot be considered valid and acted upon by the court. The state government of Gujarat has sought more time from the High Court to file the final report of the special investigation team probing the collapse of the Morbi Bridge. The incident occurred last year on October 30th, when the British-era suspension bridge on the Machu River in the Morbi town of Gujarat collapsed and led to 135 people being killed, and over 50 people were injured. The High Court had taken a suo motu cognizance of the matter last year, and the state government appointed a 5-member SIT to investigate the collapse. A division bench of the High Court, comprising the Chief Justice Sunita Agarwal and Justice Aniruddha Mai, granted the government 2 weeks of time for submission of the final report of SIT, while also observing that no further adjournment will be granted in the matter. The National Company Law Appellate Tribunal is set to begin hearing from November 28th. The plea filed by Google challenging the order by the Competition Commission of India that imposed a penalty of Rs 936.44 crores upon it. The penalty on the tech giant was imposed as a result of it abusing its dominant position with regards to the policies of Play Store, which is the digital distribution service operated and developed by Google, from where mobile apps are downloaded. The CCI based its penalty on the ground that Google has restricted app developers from using any third-party billing or payment processing services to purchase apps for in-app billing on the Play Store. The CCI held that making app developers to mandatorily rely on the Google Play billing system was an unfair practice. CCI also highlighted that Google was following a discriminatory practice for not using the GPBS system for its own app, YouTube. The regulator also directed Google to cease and desist from unfair practices, which was challenged before the NCLAT, which is an appellate tribunal for CCI. The matter was listed before the NCLAT bench of Chairman Justice Ashok Bhushan and Justice Alok Srivastav, which directed the parties, including the CCI and contesting startups, to file their replies within 4 weeks and listed the matter for hearing on November 28th. The non-government organizations registered under the Foreign Contribution Regulation Act will now have to disclose details of movable and immovable assets created by them using foreign funds, after the Ministry of Home Affairs has amended the rules pertaining to the filing of annual returns by such NGOs. In order to make the process of monitoring of NGOs receiving and using foreign funds, the MHA made changes to the Foreign Contribution Regulation Rules of 2010 and issued a notification in this regard, imposing a condition of mandatory declaration of assets by the end of every financial year. That was all on today's legal news. Thank you and keep watching Verdictum. And subscribe to our channel and download the Verdictum app on iOS and Android to keep yourself updated with authentic legal news.